Hello, everyone, and welcome to USPTO Hour, the Trademarks edition. It is May 28th, 2025, and today we are going to be talking about the Trademark Trial and Appeal Board with a little bonus content at the end where we follow up with some questions from last month. I'm Jason Lott, the managing attorney for Trademarks Customer Outreach at the USPTO, and it is my job to provide you with legal training in the field of trademarks. Whether you're a small business owner, a new lawyer, paralegal, support staff, or maybe you're one of our experienced practitioners with decades in the field, we want to make sure that you have the knowledge and tools that you need in order to accomplish your trademark goals. And specifically, we want to make sure that you are able to submit the highest quality applications that you can, and of course, avoid trademark scams. So as you can see on the screen, we have a powerhouse lineup of experts for you today, including the Acting Chief Administrative Trademark Judge and the Acting Deputy Chief Administrative Trademark Judge. I am going to introduce them in just a moment, but before I do, we have to hit a couple of quick housekeeping items. I know already that some of you are going to ask, is this session being recorded? And the answer is yes. Yes, it is. We record every week of USPTO Hour, and the goal is to post all of the recordings so that you can go back and watch them at your leisure. It is taking a little bit longer than we would like in order to get all of the recordings posted, but they will be up as soon as we can. And the same thing is true for the slides. They'll most likely be posted along with the recordings at the same time. If you are a person who wants or needs captions, you have two options available to you today. If you are okay with robot captions, you can hit the CC button, which is down in the bottom left-hand corner of your screen. But if you want live captions, you are going to find that in the chat box. And that is down in the bottom right-hand corner of your screen. There you should see the chat bubble, and you can go ahead and open that up if you are interested. Our tech team will be posting a link to live captions in there. I think Darcy might have already put it in there. And also that chat box is where you can let the tech team know if you're having some sort of technical issue with WebEx. If you have a substantive question for today, we would encourage you to use the Q&A box. Now, you might be looking at the screen right now and saying, Jason, I don't see a Q&A box. Well, I'll tell you, it is there. You do have to hunt a little bit to find it. So down in the bottom right-hand corner of your screen, you're going to see three little dots. If you go ahead and hit that little button, you're going to see an option come up, and one of them is going to be the Q&A box. So if you have a question that you would like to ask today, please feel free to use the Q&A box to ask it. Please don't put it in the chat. We're not going to be in the chat today. It's just going to be the text. I mean, look, I don't want to speak for Darcy, but I don't know. I don't think you want Darcy answering your questions about the TTAB. Maybe Darcy's a hidden expert and we didn't know it. But if you have a question, please put it in the Q&A box and not into the chat. I do want to let you know, however, there is no live back and forth happening in the Q&A box today. Instead, what we're going to be doing is collecting all of your questions, and then at the very end, I'm going to be asking Judges Shaw and Johnson live on air what questions that we can before the hour is up. We do already have a couple of questions that came in over the last week through the USPTO Hour at uspto.gov mailbox. We're going to start off with those, and then in any time we have after those are finished up, we'll try to get to any questions that came in through the Q&A. So please note, if you ask a question today and we don't get to it, please do not take it personally. We had about 1,500 people who registered for today, and even if half of the registrants came today and only 10% of them asked questions, we're still talking about 75 questions. And there just literally is no way that we're going to be able to answer all of those questions in the minutes that we're going to have remaining at the end. So believe me when I say this, it's not you, it's the volume. Okay. And also some of you might be asking for legal advice, which we cannot provide. So if we skip over your question that involves legal advice, again, it's not you personally. It's just that that's a question we cannot answer. And if you are someone who says, you know what, Jason, I get distracted by chat and by Q&A, I don't want to see it. Trust me, I'm with you. I'm the exact same way when I attend a webinar. You can turn it off. All you have to do is just sort of close it out. Okay, you can close out those boxes if you happen to open them. All right, so we are going to get into it. All right, that's enough of those housekeeping things. So it is my honor to introduce our speakers for today. We have Judge Thomas Shaw. He's the acting chief administrative trademark judge of the Trademark Trial and Appeal Board, also known as the TTAB. He was appointed to the position in December of 2024, previously serving 13 years as one of the TTAB's administrative trademark judges. Judge Shaw began his career at the USPTO as a trademark examining attorney, later serving as a senior attorney and a managing attorney, as well as an associate solicitor in the Office of the Solicitor. He's a graduate of the George Washington University and earned his Juris Doctor degree from the University of Miami School of Law. And we also have Judge Melanie K. Johnson. She's the acting Deputy Chief Administrative Trademark Judge of the TTAB. She was appointed to the board in February of 2020 with an active and varied career in IP law before joining the USPTO. These include positions in the Office of the General Counsel at the U.S. Department of Health and Human Services and Senior Counsel for Trademark and Copyright Law at DuPont, where she was instrumental in creating the company's first brand protection center. She began her career as an IP litigator as well as a law clerk to Judge Eric L. Clay of the United States Court of Appeals for the Sixth Circuit. She earned her bachelor's degree with honors from the University of Michigan, Ann Arbor, and her law degree from the Ohio State University College of Law. All right, Your Honors, over to you. I will be back at the end to ask some questions.
Thank you very much, Jason, for that lovely introduction, and thank you, Judge Johnson, for joining me here, and thank you to any viewers out there who are listening. Today's goal is to give an overview of the Trademark Trial and Appeal Board generally, and our practice with a few pointers mixed in, and then at the end we'll do some basic statistics about the board. So let's go next. So general information, next. So the board has limited jurisdiction. We only have the right to determine registrability, either to get a registration or keep a registration. We don't really have the right to decide who gets to use a mark. That really is decided by district courts and parties themselves. And as for related issues, we generally don't get into contracting or licensing disputes. We only touch on those kinds of things if we get into an ownership dispute between two parties who claim essentially the same mark. So really it's all about the right to registration. Because of that, we also have some limited remedies. We can't award damages for infringement. We cannot award attorney's fees, issue injunctions, that sort of thing. So we do have very limited jurisdiction, which just involves registrability. That said, our administrative proceedings can be faster and less expensive than district court alternatives. And we're really the only shop in town that can handle ex parte appeals. Next. So types of proceedings. The board has 5 different types of proceedings that we handle. We handle ex parte appeals, and those are appeals from refusals or rejections by examining attorneys. If your application is in the examination phase, you may get a refusal or a requirement that you can't overcome, and you have the right to appeal to the TTAB to reverse that. And that's a fairly common type of case for us. Less common are ex parte appeals from expungement or reexamination proceedings of registrations. These are fairly new proceedings to go back and have the office look at whether a mark the registration should be maintained, likely because of non-use of the mark. And these expungement or reexamination proceedings, as I said, are fairly new, so we haven't seen a lot of those, but I'm sure they'll go up in time. The other types of cases we have are opposition. These are essentially trial cases, and that would be challenged by a party that is trying to oppose a pending application at the publication stage. So the application may have cleared examination, but it is then published for opposition, and parties that feel that they would be damaged by the registration of that mark have the right to bring an opposition proceeding in front of the board. Similarly, we can handle cancellations. Those are challenged by a party of a registered mark. So if you missed an opposition, you can come in and file a cancellation proceeding, which is also a trial proceeding. with the board, and you can try and get that registration canceled if you would be damaged. Those are fairly antiquated, and we don't see many of them, a handful per year. And these are where parties are seeking geographically limited registrations. They're basically small parties that are not national in scope, and they try to coexist within geographic limits. So those are the 5 kind of cases that we handle. Next. Next. Just a chart of what this looks like. At the bottom in fuchsia is the application process from original application through examination. If it gets approved, it goes to publication, and then eventually, if it's not opposed, it goes on to registration. But at each stage of those latter 3 proceedings, you can file an ex parte appeal from examination to get an examiner's refusal reversed. You can file an opposition after publication to oppose publication if you're a third party, and you can file a cancellation proceeding after registration to get a registration canceled. There are limits as to what you can file after registration, particularly after 5 years. The grounds for cancellation narrow significantly after 5 years, but you can file on any grounds within the first 5 years. And from the board, if people are dissatisfied with the board's outcome, they can file an action in U.S. District Court and have a trial in the District Court, or they can file in the U.S. Court of Appeals. And if they lose there, then they can also go to the Supreme Court, which is fairly rare, but does happen. Most of our appeals go to the U.S. Court of Appeals for the Federal Circuit because they have a lot of experience in trademark cases. Next. So let's talk about the TTAB generally. I'll give a brief overview of who we are. Next. So the board has about 85 people now. We're actually a fairly small shop here at the PTO, but the board is composed of a chief administrative trademark judge, which is me right now as acting. We have a deputy chief, which is Judge Johnson. We have a senior level attorney who also edits the Trademark Board Manual of Procedure, and she handles a number of different policy issues. We have a managing interlocutory attorney who also manages the interlocutory attorneys. We have 15 of those, and I'll talk about them in a minute. We have 22 administrative trademark judges who issue decisions of the board. We have a chief clerk who handles sort of procedural issues relating to our decisions and our caseload. We have 10 paralegals who basically keep the cases moving through the trial process, mostly trial cases, but some appeals. And we have an administrative officer who manages the back of the shop, that is the administrative and technical staff that they keep everything humming along here at the board. Next. So what do the judges do? Primarily, the judges will issue final decisions on the merits in appeals, oppositions, cancellations, and the few concurrent use case we have. They also preside at our hearings. We have maybe 5 or 10 hearings a month. And they also review and approve orders on dispositive or potentially dispositive motions. And those are motions that might bring a proceeding to a close. Not every case makes it to a final decision for review by judges. A lot of cases might get knocked out on motions for summary judgment or motions on the pleadings of the case. So some cases are knocked out earlier on, and because those are dispositive motions that bring proceedings to a close, the judges will look at those cases as well, or those orders as well. Next. The interlocutory attorneys, those are essentially our staff attorneys. They draft and issue orders on non-dispositive motions, discovery motions, motions to compel, for example, if parties are not cooperating in the proceeding. If there are contested motions between the parties, they will address those. and any number of other complicated uncontested motions. They also, as I mentioned on the previous slide, interlocutory attorneys will draft orders on dispositive motions, for motions for summary judgment, motions for sanctions, motions to dismiss, that sort of thing, which are then sent to the judges for approval. Next. The paralegal staff are the folks who really keep the cases moving on procedural grounds and through the whole trial process. They draft and issue orders on consented motions, which are often scheduling motions, and motions to sort of move along the case, extensions of time to oppose prior to bringing in opposition. Often will suspend proceedings throughout the course of the trial case, so they'll handle motions for that, and various stipulated motions that may come up in the course of the trial. And they'll draft many of these orders for signature by a staff attorney. They also draft some orders on appeal cases. These would be requests for remand or requests for extension of time to file a brief, that sort of thing. And they also handle docket management and move cases along through the system at each point in the life of the trial case. Next. The client services branch is really important to us. We have an information specialist who handles public inquiries, either by telephone or email, and he can handle any number of questions about TTAB practice, about filing, and on the off chance he doesn't know the answer, he can forward you to somebody who may. And that's our sort of public-facing person who responds to public questions. Generally, the public should not be calling judges and should really limit their contact to the public inquiry or maybe the staff attorney who's handling the case if there's a need for a conference. We also have a hearing and decision specialist who schedules hearings and processes decisions for mailing to the various parties. And then we have a supervisor who manages the whole client services branch. Next. The rest of the TTAB team, we have a chief clerk, as I mentioned. We have an analytics and information technology group that looks at our filings and our different metrics, and so it allows us to predict workflows. And our IT group keeps things humming along. We're really an IT shop with a law office on the side or a board on the side. We have enormous IT capacity here, and they're a big part of keeping that running. We have an administrative team that, as I said, keeps the back of the house running. It's human capital, it's budgets, contracts, office space, telework, travel, things like that. Also vitally important. And we have a visual information specialist who is helping me do this session right now. Next. I'm going to go over ex parte appeals briefly, some of the meats and bounds of the subject, and then I will turn it over to Judge Johnson afterwards for a review of inter partes cases. So let's talk about ex parte appeals. Next. Ex parte appeals. These are brought after a final refusal to register in the examination stage or a second refusal on the same issue. And sometimes they're statutory refusals. Sometimes they may be requirements, such as a requirement for a disclaimer or for more information, things like that, more specimens. You must file the appeal within a set period of time from issuance of the final office action. That's generally 3 months for an application, although you can get extensions. 6 months for a Madrid application, which parties may recall is under Section 66A. Those are foreign-based Madrid applications. If you're an expungement or a reexamination proceeding, you've got a 3-month from that proceeding with an optional extension of 1 month. Just a quick tip, don't file both a notice of appeal and an extension request at the same time, because that gums up the works. But you may file an appeal and a request for reconsideration, which will kick it back to the examining attorney and suspend the appeal until the examiner has looked at your new arguments or evidence. Next. So what's the procedure? Basically, it's a mini briefing. It's not a full-blown trial. The appellant and the examining attorney will submit briefs. The applicant or appellant has the opportunity to submit a reply brief if they want to respond to something that the examining attorney has raised in his or her brief. The important thing to remember about this is that at the appeal stage, no new evidence may be introduced. All the evidence has to come in during the examination phase. If you submit it with your brief, we're not going to look at it, except under very limited circumstances. And if you have evidence you want put in the record, the proper thing to do is to request a remand back to the examining attorney. The board will suspend the appeal, and then the examiner will look at it, consider the evidence, and if he or she maintains the refusal, then it will come back to the board. So no new evidence attached to your brief or submitted during appeal. Also, appellants may request a hearing, which we can either do in person or virtually. Next. Just a quick review of the grounds for refusal, because this obviously dictates the kinds of cases we're handling. The definitional sections of the Trademark Act are in Section 45, and it defines what a trademark is, which is a word, name, symbol, or device, or any combination used in commerce to identify and distinguish goods or services from those of others and indicate source. So often we have refusals that are issued under this definitional section because whatever is being applied for isn't really a mark. It's some other indicia or matter. So sometimes you'll see a 1, 2, and 45 refusal, which is that whatever you have isn't actually a trademark. Next. And what that means is, for example, you might not actually be the owner of the matter, which is not functioning as a trademark. It might be generic. That is, nobody can really own a generic term, which is generic for the goods or services. Obviously, you can own Apple for computers, but you can't own Apple for apples as a trademark. And also, under this definitional section, the mark fails to function as a trademark. It might be merely informational matter, the kind of thing you might put on a t-shirt. It might be a universal symbol that other people need to use. It might be the title of a single creative work, which isn't really a trademark. You might have a mismatch between what you've applied for and what you're actually using the mark on. Sometimes people will misidentify their goods and services, and you can't get a registration unless you're actually using the mark on those particular goods and services identified in the application. And lastly, for example, and it's not an exclusive list, it might be a model or grade designation, right? If your mark is, EF stroke 532-221, chances are it's a model number for an appliance and not actually a trademark. Next. Continuing on in Section 2, Section 2A has the bulk of the refusals that are generally made. Section 2A, your mark might be deceptive or create a false suggestion of a connection with somebody not affiliated with you. The board no longer enforces the immoral or scandalous provisions and the disparaging provisions of Section 2A because the Supreme Court has struck them down. Section 2B, you can't get a registration for a government flag or a coat of arms or an insignia. That's to protect government entities from being able to use their own indicia. Section 2C, there's a bit of overlap here with 2A. You can't register the name or likeness of a living individual without their consent. So you can't just come in for a registration for your famous pop star or sports star without their permission. Section 2D, this is the bulk of our work. The mark that people are applying for is likely to cause confusion with somebody else's already registered or mark in use. That basically somebody else already has it for those goods and services. Next. Continuing Section 2E, the mark might be merely descriptive or deceptively misdescriptive. And that means that the words or terminology you're using or just describe the product, right? And third parties need to be able to use that terminology on their own marks. So you can't give somebody an exclusive to descriptive terminology, or it might misdescribe the product. That is that you might be saying the product has wool or silk in it when it doesn't really, so it misdescribes the product. The mark is primarily geographically descriptive. Again, you can't get exclusive rights to descriptive geographic terminology because your competitors in that region would need to be able to use that terminology. That would be sort of Washington State for apples or something like that. And the flip side is you can't register geographically descriptive matter, deceptively misdescriptive matter, because you're not from there, right? You can't say you're selling Washington apples if you're not. 2E4, primarily merely a surname. You can't register it without an additional showing of required distinctiveness. And lastly, 2E5 comprises matter that is functional. This is generally a three-dimensional product configuration. That is, you're coming in for the shape of your product. Most of these refusals can be overcome with a showing of required distinctiveness, not all, but some. And what that means is that even though the matter applied for runs afoul of one of these refusals, you can register it if you can show that the public would nevertheless recognize your mark as a trademark. For example, under 2E5, the Weber grill, that sort of bowl-shaped grill, has long been registered as a trademark, even though it once upon a time it had a primarily functional shape. Next. So 5 do's and don'ts in appeals. Do make the record complete during prosecution. Everything that we look at has to have been before the examining attorney during prosecution. If not, we're not going to look at it and we're not going to consider it. Do consider refining your arguments on appeal. A lot of people throw in a lot of extraneous arguments, we'll call them, during examination. On appeal, to try to limit your arguments to the most viable arguments to save yourself and us time. Generally, in ex parte appeals, don't argue the actual use of the involved marks in a Section 2D appeal, except in very rare circumstances. And what that means is that the board analysis in 2D is likelihood of confusion, right? So given your goods, your mark, and another party's goods and mark or services, what is the theoretical likelihood of confusion? It's not actual confusion. This is not an infringement proceeding. So actual use isn't always relevant. It may also not be relevant because the parties may not haven't been using it for long or even at all in a 1B intent to use application. You can't say, well, gee, there's been no confusion when you haven't actually used the mark. Also, the seminal case for likelihood of confusion is the DuPont case, and has 13 different requirements for analysis of likelihood of confusion. You don't need to argue ones where there's no evidence, right? So if you don't have evidence or a particular factor is not relevant, you don't need to discuss it, and there's not much point in it. And lastly, as I've mentioned several times now, please don't attach materials to your appeal briefs unless they're properly subject of judicial notice. And what that means is that there are very few things that the board can take judicial notice of, mainly dictionary definitions, maybe an encyclopedia, things like that. So the evidence must be in the record prior to the appeal, but if you want to throw in a dictionary definition, we can look at that, but very limited attachments, please. Also, you don't need to attach cases. Sometimes people attach a full printout of the case. If you want us to look at a case, just cite to it, we'll read it. You don't need to attach the case, whether it's published or not. Next. That's kind of the overview of appeals. I'm now going to turn it over to Judge Johnson, who will walk through inter partes, i.e. trial proceedings. And then at the very end, I will go over some other information, some statistics for the board about how many cases we handle and that sort of thing. So without further ado, I will turn it over to Judge Johnson.
Thank you, Chief Judge Shaw. And now we're going to talk about inter partes, or what we call trial proceedings. Now, what are we talking about? We're basically talking about oppositions and cancellations. And what makes the board unique, I always like to say, is that our trial proceedings are on the papers. You are not going to come here to our offices in Alexandria, our trial room, and put up witnesses. We don't do that. Everything is on the papers. We'll talk about that later on in the presentation, but let's go to the next slide. Okay, first, some fundamentals. when we talk about opposition, you're talking about, as Judge Shaw said, opposition to the registration of a mark. So you're talking about a mark that has been applied for, okay? Want to say that all the marks that have been applied for appear in the official gazette, which is published weekly electronically. We call it the OG, all right? Your initial opposition period to oppose a mark that has been published in the official gazette is 30 days. And if you look at this graphic at the bottom of the slide, you will see that the publication period is 30 days in blue. All right. If you oppose during that 30-day period, great. But what if you're not ready to oppose? You basically have two ways to extend your time, which can be granted another about 150 days, I believe. At the top, you see the first 30 days in like a purple, no fee. If you're not ready after that first 30 days, then another 60 days, you can request an extension. But you have to have good cause for doing it, or you have to have consent from the other side. That'll cost you $200. And still, if you're not ready after that, you can request a final 60-day extension with consent from the other side, or upon extraordinary circumstances, whatever that may be, but it'll cost you $400. So that process, that 30-day, 60-day, and a final 60-day will cost you $600. Or you can just skip all of that and do a 90 and request a 90-day extension for good cause or consent. You see that at the bottom in the green box, and that costs you $200, consent from the other side. You also, if you're not done after 90 days, if you still need more time, then you can once again ask for a final 60-day extension that'll cost you $400. All right. And the extension of time fee is per application. All right. Maximum, the extensions of time may be granted for 180 days from the publication period. So if you include the original publication period all the way to the end of a final day, 60-day extension, you're talking about 180 days. Now, if you aren't ready after that final 60-day extension, well, you may have to seek a cancellation, but more on that later. Next slide. So, filing oppositions. Oppositions, we're talking about Section 13 of the Lanham Act. An opposition is, what are you talking about? You are opposing a mark or an application. Any entitled party can do this that believes it would be damaged by registration. All right, and we talked about the timing in the last slide. And you must include the filing fee, which is per class of goods and services. Now, let's go back to that first bullet when you talk about entitlement or entitlement to a statutory cause of action. What are we talking about? Well, first of all, we follow federal circuit law. And in the federal circuit, what some people might know as standing is now called entitlement, or entitlement to a statutory cause of action. And not everyone is privileged to be entitled, apparently. In federal circuit law, a party in the position of a plaintiff may oppose registration of a mark when such opposition is within the zone of interests protected by the statute, and the plaintiff has a reasonable belief in damage that is proximately caused by registration of the mark. That also applies in cancellation of proceedings. Now, why am I talking about this a little bit? Because just last week, the Federal Circuit affirmed the board, I believe it was May 22nd, in the case Curtin versus United Trademark Holdings. Now, Miss Curtin was a mom. She also was the opposer. She was a consumer of dolls. She was a doll collector. She said, I have a daughter. And she was opposing United Trademark Holdings' application to register the mark Rapunzel. You may remember Rapunzel from your days as a kid. Rapunzel had long hair, let it down, let everybody crawl up there to get to the tower. You may have children. You may remember Rapunzel from talking to them about that nursery story. And so Miss Curtin argued that Rapunzel, everybody should have access to Rapunzel. Rapunzel is in the public domain, but UTH rather, wanted to register Rapunzel for dolls and toy figures. All right, so Miss Curtin said nobody has a monopoly on Rapunzel. It's generic or it's descriptive and it fails to function as a trademark. That's what she asserted. Well, the Federal Circuit, as I said very recently, said, Ms. Curtin, not everybody is entitled to bring a statutory cause of action before the board, before the Federal Circuit, and you are one of those people. You're not entitled. Why? Because the harm that you're saying that you would suffer is not proximate to your damages, right? You are a consumer, but the harm that you would suffer is not closely attenuated to the other harm that maybe a competitor might suffer. So you don't have entitlement, and therefore you don't belong before the board in this kind of case. So not everybody is entitled. Just want to highlight that since the Federal Circuit has talked about it recently. And usually we find that most parties who are entitled usually are competitors, but that's not the only basis that you can base your entitlement on. Next slide. So cancellations. Judge Shaw talked about cancellations earlier. That's section 14 of the Lanham Act. Basically, they're same as oppositions, but they're filed after the mark registers. So you remember you saw that chart in one of the beginning slides that I had, a lot of colors. Let's say you miss the opposition period, you miss those extensions of time, the mark that you might have an objection to actually registers. Well, at that point, you want to file a cancellation proceeding, okay? So basically, it's the same as an opposition, but it's filed after the mark registers. Now, if you file it within the first 5 years of that mark being registered, your cancellation proceeding can be based on any ground for refusal. But if you wait after 5 years, if you wait 5 years and 1 day, okay, then you only have limited grounds for cancellation. All right. So what is always available? Genericness, functionality, the mark is functional, abandonment, the mark has been abandoned or the registration has been abandoned, or the registration was obtained by fraud. Basically, that's what's available to you if you wait after 5 years from that mark registering. All right. And then we have, based on the Trademark Act, the Trademark Modernization Act, which is pretty new, a proceeding that a lot of European countries have, or a lot of countries that are outside the United States, expungement proceedings. What are expungement proceedings? Expungement, you can expunge a registration from the register based on your evidence that the registrant has never used the mark for what the mark has been registered for, either goods or services, or only partially. There can be partial expungement also. What is supposedly unique about this, Anyone can file expungement. You don't need entitlement. So if you're worried that you lack entitlement under the Federal Circuit law, you might want to look at expungement. But expungement, you have to wait to file your expungement between 3 and 10 years post registration. So unlike a cancellation, you can't wait until after the mark registers and then you have 5 years. Expungement, 3 years, and then at the outer limit, 10 years, okay? And you have to have the documents to support your non-use claim. So if you don't think that entitlement is achievable, you may want to consider expungement. Next slide. All right. So as Judge Shaw went through, there are grounds to oppose a mark or cancel a registration, right? And he outlined just about all of them. The section 1, void ab initio or non-use or lack of bona fide intent, 2A, 2B, 2C, 2D. We always find likelihood of confusion, 2D, in just about every case. 2E, so the descriptiveness registrations, but also the descriptiveness refusals, rather, but also 1, 2, and 45, or 1, 2, 3, and 45. When you're talking about genericness, you're not the owner, or there's a failure to function problem. Also, abandonment can be used as a ground, or dilution can be asserted as a ground, and that's dilution by blurring or tarnishment. And of course, fraud can be grounds. Next slide. So, what authority do we use, or are you supposed to use, when you come before the board? Well, the federal rules of civil procedure apply wherever applicable and appropriate, and except otherwise provided. Basically, use the federal rules of civil procedure. Our substantive law is the Trademark Act, also known as the Lanham Act, also known as the Lanham Act. Our binding decisional law, U.S. Supreme Court, U.S. Court of Appeals for the Federal Circuit, our precedential TTAB decisions. And a lot of times we find parties will cite in their briefs decisions from outside of the, not Federal Circuit law, not U.S. Court of Appeal, not U.S. Supreme Court law, and not TTAB precedential decisions. Those decisions might be persuasive, but we don't have to follow them, okay? So just understand that. As far as evidence is concerned, we follow the federal rules of evidence unless you stipulate otherwise. And I also want to say a lot of people cite the TMEPs. Don't do that. That's the Manual of Examining Procedure. There is a TBMP. That's the Trademark Trial and Appeal Board Manual of Procedure. That's our procedure. It does not have the force of law, but definitely look to it because we have all the sites and all our case sites and all of the federal rule sites and other sites that you may need to help with your case. Next slide. All right. So generally, this is going to be offered at a high level. Inter partes timeline. So opposition, cancellation, timeline. First, let's talk about pleadings. So pleadings define the issues in the case. What are you talking about? Basically, a complaint. In oppositions, the complaint is called a notice of opposition. In cancellations, the complaint is called a petition for cancellation. And basically, you're talking about notice pleading, a short and plain statement of your entitlement to oppose or petition to cancel, Why do you believe that you will be damaged by the registration of a mark or the existing registration? Why are you being damaged by it? And also, you have to state the grounds to give the other side fair notice of the basis for each of your claims, and it must be plausible. Then there will be an answer, all right? You may assert your affirmative defenses in an answer. And then there may be a counterclaim if plaintiff pleaded registrations in the complaint. You can counterclaim to cancel those registrations, and the plaintiff will be allowed time to answer that counterclaim. Next slide. So pleading tips. This is important. You don't need to outline your entire case or evidence at the pleading stage, all right? Now this next bullet is a pet peeve for many judges. Aside from pleaded registrations, exhibits to pleadings are not evidence at trial on behalf of the party to whose pleading they are attached. So outside of those pleaded registrations, don't attach anything to your pleading document. Don't do it because we won't look at it. The defenses must set forth sufficient facts to provide fair notice for the basis of each defense. Also, the time to act against an application runs from when the mark was published for oppositions. So that usually means lashes and acquiescence, which usually you need a long running time to prove those, are generally unavailable defenses in oppositions. And for public policy reasons, some defenses aren't available against all grounds. For example, you have equitable defenses like lashes, estoppel, unclean hands, fraud, acquiescence, mere descriptiveness. Those aren't available when you're talking about something in the public interest. The public interest, sometimes the public needs to be able to oppose marks, cancel marks that would be contrary to public interest. So those defenses, those equitable defenses, usually unavailable. Next slide. All right. Now let's go to discovery. We have a discovery phase in our trial cases. After the board institutes the institution notice, you'll have a discovery conference, which is basically, if you're familiar with federal litigation, it's the Rule 26F conference. The board may participate. We usually don't, but we can if you request it. Initial disclosure, well, then the discovery phase will start. You'll have initial disclosures under 26A. You're supposed to disclose individuals likely to have discoverable information and those documents which may be used to support your claims or the defenses that you put in your complaint. All right, and we also have a discovery period. In the discovery period, this is when you serve your interrogatories, requests for productions, you may take depositions, you may serve requests for admissions, and you would disclose your experts. Discovery generally closes 180 days from its opening, although sometimes due to whatever happens during the development of the case or the progress of the case, a lot of times the discovery periods will be reset, testimony periods will be reset. So definitely pay attention to not only the initial institution order, which will lay all of that out, but any subsequent scheduling orders that might issue. Also, if you want to find out all about our discovery process, which is a little bit different from what you find in federal court, look at TBMP, that's the Trademark Trial and Appeal Board Manual Procedure. Section 400, which talks about discovery, and the trademark rules 2.120K, 2.121, and 2.122. Next slide. So, discovery tips. Yes, discovery and board proceedings are generally more narrow than what you would find in a district court. Absolutely. Discovery requests must be served early enough so that the responses will be due no later than the close of discovery. This is something that we find people struggle with a lot. Okay. Also, we expect you to cooperate, the parties to cooperate and make a good faith effort to meet their discovery needs for your adversary. A lot of times people are fighting during the discovery process. I know it happens. We like for you to cooperate because we don't want you to file a whole bunch of motions about things that you could have worked out. And that goes to the last bullet. You can't file a motion to compel unless you've made a good faith effort to try to resolve the issue first. And so, what we would like to see as proof of your good faith effort is copies of any email or correspondence evidencing your good faith effort with your motion. Put that with your motion. But really, we'd like for the parties to get along so we don't see those types of motions. Next slide. All right. So when we talk about inter partes cases, we have a discovery phase and we have a trial phase. And I think in the beginning of the presentation, I talked about how the board, our trials are on the papers. So you don't bring your witnesses in so the judges can look at them, look at the credibility. They're not subject to cross-examination in the box, all of that. No, our trials are on the papers. So TBMP 700, number 1, talks about the trials. Number 2, we do have pretrial disclosures. And then we have the plaintiff's trial period, which is usually 30 days. Now, interestingly, you can take the testimony. So imagine you putting up a witness in court. Well, here you take testimony. You can have testimony depositions. You can have testimony declarations, but that serves as the official testimony, right, for trial. We also have a device here at the board called a notice of reliance, which is quite different from what you would find probably anywhere else in at least the federal system and maybe state courts too. Because our trials are on the papers, you have to file a notice of reliance early in the process. It's only for certain types of documentary evidence. You have to tell us what claim this goes to or what it's supposed to show, what this document is supposed to show. And you also have to outline what the material is and why is it relevant, right? So, discovery materials. You can find the rules for discovery materials because those are the materials that you took during discovery, all right? Even discovery depositions. You can't automatically insert them in a trial in your trial. You have to use a notice of reliance. That's in rule 2.120K, not J, K, 3 Romanet 1. And it's very important. A lot of people get tripped up about this. It's very important that you look at Rule 2.120K3 Romanet 1 because it will tell you who can put in what and how. Just like registrations, all right, 2.122D2. So let's say you want to put in a registration, you want to put into evidence a registration that was not pleaded. This is where you would do it through your notice of reliance. Look at 2.122D sub 2 and printed publications in official records. Trademark Rule 2.122 E will guide you through that. Now, why? This is a very interesting portion and one that has changed throughout the years. The printed publications and official records. Official records are usually government records, right? But printed publications, we find that now most of the printed publications that we get, and printed publications means things that would be generally available in the public sphere. Think about what you might be able to get at a library, okay? But now the printed publications that we're getting in our cases are internet downloads, website printouts. Those are the printed publications that we're seeing, okay? Well, if you want to put something in using an internet web page, and it could be a social media page, a non-social media page, but still from the internet, what you definitely need to have on that page, on every single page that you submit to us, is the URL or the date accessed, and also the URL, so the full URL, as well as the date you access that material. So if you don't have that on there, that internet material that you put in might be thrown out. We see a lot of people make that mistake, or they'll have part of the URL, but not the whole URL. Make sure you have the whole URL or the source URL, as well as the date that was accessed. That's very important. You access the material. And then also during the plaintiff's trial period, if the plaintiff really hasn't done anything, failure to take the testimony or evidence, there might be a 2.132 motion that's for involuntary dismissal. Then after the plaintiff's trial period, we have the defendant's trial period, which is another 30 days. Same rinse, repeat, right? Except for the 2.132 motion. And then after the defendant's trial period ends, you have a rebuttal period. Now, the rebuttal period is usually 15 days. I just want to say here, we see a lot of parties putting in the rebuttal period, arguing things that were not argued by the defendant. You can't introduce, as Judge Shaw said, you can't introduce new evidence during the rebuttal period. You just can't do it. So next slide. We just have some trial tips. I just want to highlight, raise your substantive objections during oral deposition and maintain them in a brief. And then also, potential witnesses must be disclosed in pretrial disclosures or timely supplementations. Next slide. Just
So,
on your briefs.
Judge Johnson, sorry, this is Jason. We are almost to the top of time, and I know that Judge Shaw still has a couple slides to go. Do you mind if we jump ahead to Judge Shaw and he can talk about some resources? Is that okay?
Yes, he can talk about resources. We have a whole lot of other slides to talk about. However, just generally, we have a lot of briefs. Just make sure you look at the page limits, and also our hearings. They can be online or they can also be in person. You can request a hearing, but you don't have to have the hearing. I'm going to go back to Judge Shaw.
Thank you, Judge Johnson. Obviously, if you give us a microphone, we're just going to talk and talk and talk until we run out of time. So obviously, we'll have to get back to some of these trial issues in a future USPTO hour. Since I'm running out of time, real quick, TTAB resources. We have the rules and the statute online at the links on the page here. We have the trademark manual examining procedure. We have the board's manual of procedure. We have TTAB view, which are electronic dockets of publicly available case files. We have decision summaries in PDF form, and we have the official gazette, which has marks pending for registration after publication, and we also have board decision summaries in the official Gazette, which is now the EOG. Next. Backing up a little bit, we have the general USPTO links to the USPTO homepage, obviously, has a breakout page for trademark examining operations, and then the board's page is on there as well. Next. I think that concludes it, and I apologize to the trademark folks, Dan Vavanese and Amy Cotton. We have run over and completely mismanaged our time, but judges have a tendency to do that. So I apologize. We'll get them back in a future week, and we'll get questions in the future.
That's right. Well, thank you very much, Judge Shaw. We had a lot of good questions that were coming in through the Q&A box. So a big thank you to all of you who were asking questions. Just a couple of quick things to note there. Some of you were asking some questions that are more basic trademark questions, so we probably wouldn't be able to get to those anyway. But we have lots of information that is available to you on the website, and so you might be able to answer some of your own questions. Or we also have things like our Trademark Basics Bootcamp. We have the Trademark Basics webpage. We have our Trademark Registration Toolkit. So for a lot of those questions, you might be able to find answers, even though we're not going to have a chance to answer them today. And so as you can see, we have our acting commissioner as well of trademarks. Dan Vavanese is also the deputy commissioner for trademark examination policy, ready to go, because we were going to talk about some compare and contrast things between the TTAB and some Trademark Modernization Act proceedings. I'm not going to have a chance, obviously, to do that today. But for those of you who are interested in those other proceedings under the Trademark Modernization Act, such as expungement and re-examination, we are going to be covering those at the end of June. We have one of our experienced practitioner webinars that is coming up. That'll be on June 25th. 24th, sorry about that, June 24th at 2 p.m. Eastern. We'd encourage you to register for that, and you're going to hear all about the various proceedings, which are going to be different than some of the proceedings you heard about today with the Trademark Trial and Appeal Board. So a big thank you to all of our experts for being with us today. I know the folks, based on what I've seen anyway, the folks have really appreciated the great presentation that you gave. They're all very interested in a copy of the slides. And so as I noted off the top today, the slides will be made available to you. It'll probably be happening at the same time that the recordings are posted. Please keep an eye out for that. And a big thank you to the tech team as well for keeping us going today. So thank you all for being here. We appreciate it. I know we're 2 minutes over. Apologize for taking up 2 minutes extra of your time. We want you to be able to get back to your day. So thank you so much for being here, and we will see you next time. Take care.